Good morning, my lords and my lady. May it please you, I am Christoph Rodriguez. I appear for the appellant this morning, and I'm instructed by Ms. Mada Utley of Alum Chambers.
Please continue. Can I just check first that the sound and vision is working at the Trinidad end?
Good morning, my lord. Kyle Taklal Singh for the respondent. Are you hearing and seeing me clearly?
Yep, well, you're loud and clear as well, so that's good news. Do put a hand up if at any stage there's a break in transmission or anything that's making it difficult for you to hear what's being said.
Much obliged, my lord.
Very good. Please continue.
Grateful, my lord. My lord, this morning, the structure of my address to the court would take this format. First, I will address the appellant's case, and after that, I will address the respondent's written submissions. So, the appellant's case is that Section 16.1 of the Registration of Deeds Act of Trinidad and Tobago applies on the facts and circumstances of this case, and on a proper construction of Section 16.1 of the appellants having registered their deed of assent first in time should prevail over any subsequently registered deed. So the first question I will address, of course, is the applicability of the Registration of Deeds Act. And as we have set out in our submissions from paragraphs 50 to 53, which can be found at page 802 of the electronic bundle.
Yes.
Yes. The primary function of Section 16.1 of the Registration Act is to create a system that governs priorities as between deeds dealing with the same piece of land. This system requires that a person who acquires an estate or interest in land under a deed should register that deed promptly if he is to ensure that a person who acquires an estate or interest in the same land under some later deed is not to obtain a prior claim to the land by registering that deed first. We say that Section 16.1 is sufficient by its clear terms to regulate and govern any competition for priority as between two or more registered deeds affecting the same parcel of land, unregistered land, and as between registered and unregistered deeds, but deeds that are registrable. In that regard, I wish to point the court, of course, and I'm going to get into the structure of the decisions that I'm referring to. I want to point the court to the decision, the recent Privy Council decision coming out of Trinidad and Tobago, the decision of Delore and Guardian Asset Management Limited, which can be found at page 1088 of the electronic bundle. Now, my lords and my lady, I'm going to go through the authorities systematically at some point in my submission.
So you don't want us to go there now?
No, I don't want you all to go there right now. I'm just mentioning that these are the authorities that I will get to in relation to that particular point. There's also the authority of Warburton and Loveland, which is an authority from the House of Lords, an 1831 decision that specifically deals with the Irish Act and deals with the Section 16.1, which we say is almost indistinguishable from Section 16.1 of the Trinidad.
Why do you say that the Trinidad legislation is based on the Irish Act rather than the English Act, which is what one might expect?
Milady, we have set out the terms of the Irish Act, Section 4 of the Irish Act and Section 5 of the Irish Act. And we are saying that the language in both the Trinidad and Tobago Section 16.1 and the language associated with the Section 4 of the Irish Act are indistinguishable in terms. And therefore we say that, like many of the other countries that were colonies at the time, some of them adopted the English Act, and some of those colonies adopted the Irish approach.
But in a sense, the Trinidad one might be said to be a bit of a
hybrid.
A bit of a hybrid, because the Irish Act in its Section 5 doesn't include a reference to bona fide purchases, does it?
Purchases.
It talks about, it talks about an unregistered deed in certain circumstances being fraudulent and void, but does it include bona fide purchasers
Or not, well,
as
purchases for
people
value.
against whom that fraudulence and voidness takes place?
My lords, the explicit words or the express words purchasers for valuable consideration and mortgages are not used in the Irish Act.
No.
But what I understand the language, or what I understand those terms to mean, where they talk about statute merchants and different things, I understood that to mean purchasers for value. Now, it may not necessarily mean that, but the
So you're
point
saying
is,
the Irish Act also is limited to purchases for value?
no, please, milady. What I'm saying is that Section 4 of the Irish Act is a totally different section. Section 5 of the Irish Act, as Lord Resdale said in Bushell and Bushell, resembles Section 5, well, Section 1 of the English Act. So Lord Resdale said that the Irish Act is an act of a completely different nature by virtue of its Section 4. But Section 5 of the Irish Act resembles what would have been the English Act.
Well,
So
that's
it
why I'm
does,
suggesting there's an element of hybridness.
that please, my lord. I have said it as an element of hybrid in my written submissions. I have said that Section 16.1 is a replication of Section 4 of the Irish Act, and 16.2 is a replication, so to speak, of the English Act. So in that regard, it is in fact a hybrid. But when I went further into the decision of Bushell and Bushell, it appears to me that Lord Resdale has in fact said, when he was dealing with that case, that Section 4 of the Irish Act is as a section that is totally different and does not appear in the English Act. But he himself says that Section 5 of the Irish Act resembles, and he uses the word resembles, so I take it to mean that he's not saying that it is exactly the same, but he says that it resembles what the English Act would look like.
At some stage, Mr. Rodriguez, I'm not sure actually either side have really fully approached this problem in their written materials. I, for one, would be grateful if you could specifically address the position of those who take under a vesting assent, as opposed to those who take under some transaction where there's a sale or a mortgage, because of the consequence of your submissions in a way detracting from one's general perception that someone a beneficiary in an estate who takes property under a vesting assent isn't thought to be capable of being better off than the deceased. And I imagine it's accepted that at the moment when the deceased in this case died, he was still liable to give possession of the property to Mr. Boville.
Yes, please, my lord.
Yeah, I think that's common ground, I suspect it is, but in which case it will be helpful if at some stage you deal with what seems to be at least a potential problem in your submissions, that it would promote beneficiaries in an estate into a better position than their testator, which isn't something I think has been looked at in any of the 19th century cases. I don't think any of them are about a vesting assent.
Well, the cases from the 19th century do speak about the fact that the section, or at least the Irish section, makes no distinction between purchasers for valuable consideration. Sorry?
And volunteers.
And volunteers.
Yeah.
That is expressly said in the case law.
Yes.
Right? So it makes no distinction. And the section 16.1 as well from Trinidad and Tobago makes no distinction. What it does is that it asks persons to register first. And I'll come to the case law in relation to it. But it says that registration is the test of right and interest.
So what do you say was the position as between Mr. Choi and Mr. Boville in 1980, say, as to who owned the property?
Milady, what I say is that there was a valid transaction between those parties, and equity would enforce that transaction between those two parties.
Well, he doesn't need to enforce it. Why would he enforce it? Because why would he have to rely on equity? Didn't the deed transfer the legal title and the beneficial title from Mr. Choi to Mr. Boville?
Milady, we say no. We say that the equitable interest was passed through the deed, and the legal interest in the title remained with Mr. Choi.
Why?
Because it was not registered at the time. But I will come to those points in
So
my
you
submission.
you say that despite what the Conveyancing and Property Act says, actually the registration is a requirement before legal title is transferred under a deed.
Yes, please, Milady. We say that that is the effect of Section 16(1) of the Act.
But is there any authority about legal title, showing that legal title doesn't transfer, not necessarily dealing with the priorities, but showing that legal title is not transferred unless and until a deed is registered in Trinidad and Tobago?
We say, please, my lady, that the effect of the decisions that emanate from Section 4 of the Irish Act are just that it is only upon registration that the title passes at law and in equity. That is the effect of the Act. The Act says that it is only good and effectual at law and in equity upon registration. So we say that the effect of the Act, and when we go through the decisions of Lord Resdale and the decisions that follow, it is very clear that the effect of Section 16(1), as it is with Section 4 of the Irish Act, is that title only passes properly. It is only good and effectual at law and in equity when there is registration.
That seems to be different from the position which appears to have been common between the parties in the courts below. Because if I understand the position correctly, both parties approached the case on the basis that the conveyance transferred ownership. So you're departing from that.
My Lord, in the courts below, what I understood the position to be, particularly at first instance, was that the appellants today relied on Section 16(1) of the Act, and the trial judge also relied on Section 16(1) to say that the lack of registration,
And my mouse isn't working.
and the appellants at first instance and the trial judge relied on Section 16(1) to say that the failure to register meant that title had not passed and that the appellants had obtained a priority of interest in the property as a result of their registration first in time. Now, what seemed to be lacking in the courts below was that there was not a sufficient discussion about the case law in relation to Section 16(1). There was clearly no considered discussion in the cases in the courts below about Section 16(1), about the genesis of Section 16(1), about it being almost in indistinguishable terms from Section 4 of the Irish Act, the authorities that came out of the Irish Act, not just the authorities that existed in the United Kingdom, but we've also cited the decision of Derbyshire and Derbyshire, which is an Australian High Court case.
Can I just test this as a little small practical example? Forget the rather convoluted facts of this case, but suppose A sells land to B and executes, and the sale is completed in the sense that the conveyance is signed and executed, the deed is executed and delivered to B. Does B have to register it as a condition, for example, of seeking an order for possession against A, if A then fails to hand over the property physically? My understanding up to now has been that that 16.1's got nothing to do
Quite.
with a situation where there is no registered entry at all. It's about priority between competing registered entries. And in those circumstances, B would be able to say, I've got legal title by virtue of the deed of conveyance. That gives me a legal right to possession, and I can sue for immediate possession of common law. And it's no defence to A to say, well, you haven't registered yet.
That's correct, please, my lord. That is exactly the position that we are expressing, that as between the immediate parties to the transaction remains good between the parties,
Right.
good and effective.
What do you mean good and effective? Sorry, go on. What do you mean good and effective?
It means that A, who has purchased from B, can enforce his right against B, but as against a third party who, if he registers his transaction before A registers his transaction, then he has fallen in priority to that party. But as between A and B,
I understand that, but I don't understand how your concession as to the right of B, without having to register, to seek a legal remedy at law for possession of the property, can stand with the proposition that title doesn't pass until registration.
well, my lord, I'm saying that the effect of the case law that we have read is that the title only becomes good and effectual upon registration.
Against third parties with a prior registered deed.
That's correct, please, my lord.
I understand that entirely.
Sorry if I confuse the court, but what I
Perhaps
meant...
it will become clear. Perhaps it will become clear, but at the moment, I don't understand what your case is in response to my Lord Doherty's question, which is, are you now saying that legal title, as between A and B, only passes on registration, so that despite what the Conveyancing and Law of Property Act seems to indicate, actually you have to register in order to get legal title from your seller?
Milady, what I say in response to that is that as between the immediate parties to the transaction, A and B, legal title passes. However, as between third parties, registration is required so that you will have a priority.
Yes, that's your case, but you can't have legal title passing from A and B vis-à-vis A, but not vis-à-vis some third party. That's not something that you can have legally. Either he's got legal title or he hasn't got legal title. But, and the question of whether he then forfeits that title because of failing to register is what the case is about.
Yes, please, Milady.
Right, but it's... All right, well, let's proceed and see if it becomes...
But let me clarify for your ladyship's position. What I am saying is that legal title passes between A and B as the immediate parties to the transaction, and that if A does not register his title, then he loses the priority of his interest. His interest is postponed to those who have registered before him.
Yeah, and that's the question. Is that the case, or is it only the case if there's a purchaser for value?
That's the question, please,
Yeah.
Milady. And we say that Section 16.1 is a section that is wholly different from Section 16.2, while Section 16.2 of the Act specifically protects purchasers and mortgagees against unregistered instruments. Section 16.1 creates priorities, and it involves the postponement of your priority if you do not register. So that's the effect of the case. And I will just go through. So we say that Section 16.1 is sufficient by its clear terms to regulate and govern any competition for priority as between two or more registered deeds affecting the same parcel of unregistered land, and as between registered and unregistered but registrable deeds. We submit that 16.1 applies to this case because it involves a competition for priority between three registered deeds: the appellant's registered deed, which came first in time, June of 2014, the Bovell deed, which comes in December of 2014, and the second respondents, or the grants deeds, which come in August of 2015. We respectfully submit that the Court of Appeals analysis of the 1979 deed as unregistered is incorrect. At the time that the matter was extant before the court, the deed was in fact a registered deed. It was registered in December of 2014, so that a competition of registration arises.
But they can't, so you're saying they're in a worse position having registered it late than they would have been if they had not registered it at all?
No, please, my lady. What I'm also saying is that even if we analyze the deed as an unregistered deed, then Section 16(1) also deals with deeds that are registrable but unregistered versus deeds that have been registered. And that is precisely what happened in the decision of Delorier. In Delorier, the deed of settlement remained unregistered. The deed or the judgment creditor's charge was registered. The board in that case said that Section 16(1) of the Registration of Deeds Act was sufficient in its clear terms to regulate the competition between the unregistered deed and the registered deed. You see, my lady, they are not, the issue of priority kicks in or only is enlivened when somebody registers. So you can have no priority. You can have no place in that system of priority if you do not register. And in that regard, a registered deed will always have priority over an unregistered deed. Section 3 of our Act makes that clear. And if I may just move quickly to Section 3 of the Act. Section 3 can be found at electronic bundle, page 829.
Sorry, say again?
829 of the electronic bundle.
Yeah. Yes, got it.
So it says, every deed executed in Trinidad and Tobago or elsewhere in the presence of and attested by one witness, at least not being a party thereto, shall be held and taken in law to be a specialty, and shall otherwise as a deed be valid and effectual for all purposes. And nothing in this section shall give an unregistered deed any effect or operation which by law is dependent on registration. Now that section is very clear, because priority is dependent on registration under Section 16(1). So if you have an unregistered deed, you cannot get onto the system of priorities, because this section says an unregistered deed will have no effect or operation if it has not been registered.
Well, it says, doesn't say that, it says won't give an unregistered deed any effect or operation which by law is dependent on registration.
That's correct.
What we're looking at is the content of those last 7 words. What is by law dependent on registration?
And we say that priority is dependent on registration under Section 16(1).
Right, but you don't now seem to be saying that the passing of legal title is dependent on registration.
The lady, entirely so. I'm not saying that the passing of legal title is not, because it says here that it is good and effectual for all other purposes.
I'd rather read the final clause in Section 3 as being directed to the sort of situation where a deed had no legal effect unless it was registered, and I think a deed of assent may fall into that category. It requires to be registered in order to have legal effect. Is that not what the sort of thing Section 3 is getting at, the final clause?
My Lord, I would have to disagree with the court's position on that, because what it does say is it's very clear that it is an unregistered deed. It doesn't make any distinction between categories of deeds. For example, a deed of assent or anything. It simply says an unregistered deed. And that is where the system of registration, or the priorities created by section 16.1 makes.
It's saying an unregistered deed will be valid and effectual for all purposes, but then there's a caveat. It's a carving out from that general provision, which is saying, but not in a case where a deed has to be registered to have legal effect. That's all that the final clause is saying. On my reading of it, anyway.
Well, it certainly covers the deed of assent, doesn't it? But the deed of assent, as I understand it, would not be valid and effectual if it's not registered anyway. I mean,
Yes, please, my lord, it will not. Again, my lord, my reading of section 3 is that it says that deed shall be valid and effectual for all purposes, and nothing in this section shall give an unregistered deed any effect or operation by law which is dependent on registration.
so in the case of a deed of assent, that means all its effect is dependent on registration. But your case, I understand it is, in the case of a conveyance, it has some effects which are dependent on registration, though not all.
Not all, please, my lord. And one of the effects that is dependent on registration, we say under section 16.1, is priority. Priority is dependent on the deed being registered.
But I mean, take a situation in which executors assent to the vesting of a piece of land in the beneficiary named in the will. But why should the ability of the beneficiary then to get legal possession of the land, relying on the deed of assent, depend upon registration? There wouldn't be any priority dispute with anybody.
So I think
16.1 is only about regulating priority disputes, I thought you said.
That's correct, please, my lord.
Yes.
And it regulates priorities between competing deeds. Where there is no competition taking place, then there's no issue. There's no 16.1 does not come into play.
Yeah.
But the Succession Act says that an assent or conveyance is not effectual to pass any estate or interest in land unless it is registered.
Yes, please, my lord. Section 18 of the Act says that. In that case, it requires registration.
Right, so what section 3 is saying, question whether it's all it's saying, is by declaring in section 3 that the deed is valid and effectual if it's attested by one witness, etc., we're not cutting across any other legislation which actually says deeds must be registered.
Yes, please, my lord.
So if you hadn't registered your deed of assent, you couldn't, and somebody said, well, look at the Succession Act that says it's only effectual if you register it, you couldn't then point to section 3 and say, yes, but look, this says as long as it's witnessed by one person, it's valid and effectual for all purposes. This doesn't override the more specific provision.
Certainly, please, my lady, does not do that, but we say it is also applicable where any deed is unregistered. Any deed, because if you look at section 16.1, please, my lady, section 16.1 starts with a mandatory imposition that all deeds affecting the interest or estate in land in Trinidad and Tobago, both at law and in equity, shall be registered.
Yeah, and the question is what is the consequence of the parties for not registering their deed?
And as, please, my lady, as Lord Tyndall, Chief Justice, set out in Warburton and Lovedale, the consequences are provided in the section.
Yeah.
The consequences for non-registration are provided in section 16.1, which is that you lose your priority as against any other sale, disposition, or deed or conveyance. So those are, in fact, the consequences of non-registration. Your lost priority or the postponement of your priority, and it is all set out there in 16.1. As it is set out in section 4 of the Irish Act.
And you just ignore 16.2 then?
No, please, my lady. 16.2 deals with a very specific situation where the deed is unregistered and a subsequent purchaser, not a previous purchaser, a subsequent purchaser or mortgagee takes for valuable consideration as against an unregistered deed. And we will see the effect of 16.2, in Ramdeo and Payne, which is a decision of Lord Russell coming out of Trinidad and Tobago. We will understand the effect of 16.2 as against 16.1 when we look at the decision in Ramdeo and Payne, please, my lady. And we will also see that the board is saying in the lorry that 16.1 is by itself sufficient to regulate competition for priorities. Now, the board describes 16.2 perhaps as belts and braces.
Well, they said it didn't arise in that case, so they weren't going to decide it.
Certainly, please, my lady, they did say that, but they also went on to indicate, please, my lady, that perhaps, as Mr. Keeley had argued in that case, perhaps it was merely belts and braces. But what did not come before the board in the lorry was the decision of Ramdeo and Payne, which was a decision of Lord Russell of Killowen, who actually had to apply 16.2 on the facts of Ramdeo and Payne. And he said, in that case, or as I say...
Well, are you going to take us to that case? Because it's easier to understand these points if you show us the authorities.
Yes, please, my lord. I was still on the applicability point, please, my lord, of 16.1.
We better stop bombarding you with questions. I know you do want to take us through the authorities, and I can see why you do.
Yes, please, my lord. My lords and my lady, the only thing I'll ask for is that I, of course, would be happy to answer any of the questions that the court poses, but I suppose that I will get back some time, injury time, so to speak, if I have to slightly go over my speaking time.
We don't allow injury time in this proceeding.
I understand, please, my lord. So I go back to the point of saying that the general rule is that deeds take priority strictly according to the time of their registration. And I go next. So my starting point is that 16.1 of the Act is applicable because this case involves a competition between different registered deeds for priority. And even if it is an unregistered deed, as the Court of Appeal, we say incorrectly treated it because it was a registered deed. Even if it is an unregistered deed, the 1979 deed, Section 16.1, in its clear terms, is sufficient to treat with an unregistered deed versus a registered deed. So, in terms of the construction of Section 16.1, the interpretation of Section 16.1, the decision of Lord Hodge in the recent authority of the UK Supreme Court case of the Queen and the Home Secretary, which can be found at the electronic bundle 1160, sets out the modern approach to statutory interpretation. I will not take your lordship and my lady through the entirety of what Lord Hodge has said. I think the court sufficiently understands. But I will just quote what he says from Lord Nichols in Spath, Home. The task of the court is often said to be to ascertain the intention of Parliament expressed in the language under consideration. This is correct and may be helpful so long as it is remembered that the intention of Parliament is an objective concept, not subjective. The phrase is a shorthand reference to the intention which the court reasonably imputes to the Parliament in respect of the language used. So what we are seeking, of course, is the objective assessment of the meaning of the words used by the Parliament. And we say that Section 16.1, and Lord Hodge, goes on to say, in relation, he says that no external aid can displace the meaning conveyed by the words of the statute that are after consideration of the context, are clear and unambiguous, and which do not produce absurdity. We say that Section 16.1 of the Registration Act, after an objective consideration of its context, is clear and unambiguous in its terms. I was saying before we turn to 16.1, we would have elucidated on some of the sections that preceded Section 16.1. For example, Section 3.
We've looked at that.
We've looked at that, please, my lord.
As you've got limited time,
Yes, please,
it's
my lord.
helpful if we see some of the 200 years or so of authority.
Authority. Please, my lord.
We know the principles of statutory interpretation.
Indeed, my lord. And I also want to take, my lord, to Section 4 of the Act, which says, any deed, although it is not required by law to be registered, may, at the option of any party to the deed, be registered under this Act. And we say that deeds in relation to interest in land are required by law to be registered under Section 16.1. Section 16.1 is very clear. So Section 4 does not arise for this type of deed. Section 16.1 says, every deed whereby any lands in Trinidad and Tobago may be affected, both at law and in equity, shall be registered.
I don't think there's any dispute, I may be wrong, that the 1979 conveyance was a deed which was required to be registered.
Yes, please, madam. Grateful.
As I understand it, that point isn't being. I can see a hand up. Yes. Yes, please.
Sorry, my lord, I was frozen for a second, but you're back. We're back.
Okay.
Okay.
Apologize.
Yes, carry on.
Yes, please, my lord. So we start the analysis of Section 16.1 by the point that my lord was making, which is that there is no controversy, really, no dispute over the fact that the 1979 deed was a deed that was required to be registered because it was a deed that affected an interest in land, both at law and in equity in Trinidad and Tobago, and there was a requirement to register that deed. Section 16 then continues by providing priority for registered deeds according to the time of registration against every other deed, conveyance, or disposition of the same land or any part thereof. In so doing, we say that Section 16 is regulating the priority of deeds in relation to the same piece of land according to the time of registration and providing the consequences for a failure to register a deed. Section 16.1 is not without judicial consideration. Again, we have submitted that Section 16.1 is almost indistinguishable in terms from Section 4 of the Irish Registration of Deeds Act of 1707. And now is where I will take the court through the case law. My judicial analysis starts with the decision of Bushell and Bushell, a decision of Lord Redesdale in 1803. In that case, the learned Lord Chancellor laid down what has been described and adopted as the most authoritative exposition on the Irish Registration Act, in particular Section 4. I'm taking from Electronic Bundle 975. I think this is the point at which my lords and my lady will wish to look at the electronic bundles.
Yes.
Right. So the first point that Lord Redesdale makes in Bushell and Bushell is that there is a material difference between the Registry Act in Ireland and those in England. And at that time, the English acts were the Middlesex Registry Act and the West Riding Yorkshire Act. In fact, in one of the cases, it is discerned that both acts were passed in the same year. The Irish Act was passed in 1707, and the Middlesex Act, I believe it was, that was also passed in 1707. And Lord Redesdale comments on that fact. He says they both passed in the same year, but they were of a very completely different nature when one looks at Section 4 of the Irish Act versus what is contained in the English Act. So he goes on. He says there is a material difference between the Registry Act in Ireland and those in England. The difference, it seems, the difference in these acts seems to have been what has produced the difference in the decisions upon them. That difference being the priority which the statute in Ireland gives to a prior registered deed. And that is at Electronic Bundle 975. Now, these are very old cases, please, my lord, and they are.
Yes.
So he starts over, there's a material difference.
Yeah, we've read that.
Right, grateful, my
You've
lord.
only got 3/4 of an hour, so you need to...
Speed it up a bit.
well, it's up to you, but if you want to get through the cases, you have to be quite efficient, I would thought.
Yes, please, my lord. The Irish Act has the effect of giving priority to registration, and that is a priority which a court of equity or of law cannot take away. That's at Electronic Bundle 979. He goes on a true construction of the Irish Act, the instrument registered must prevail against a subsequently registered.
Where are you reading from?
This is at 979 of the Electronic Bundle.
The last paragraph.
Yes, please, my lord. Last paragraph. On the whole of this case, therefore, I have no sort of doubt of the true construction of this act. The instrument registered must prevail against a subsequently registered instrument by force of clause 4. He goes on, the interpretation of section 4 of the Irish Act is not at all grounded on the next section of that act, which avoids unregistered conveyances. That is a provision of a totally different description, which like like our act, deals with unregistered dispositions in favor of a purchaser for value or a mortgagee. And also, the Middlesex Registry Act does the same. He goes on, the meaning of Section 4 is to give full effect by force of the registry, even to articles, if registered, against a legal conveyance. So that the Act has given to contracts registered a force and effect with respect to lands themselves, which they have not in England, there being no such clause equivalent to Section 4 of the Irish Act in the English Registry Acts. And it will answer for all purposes, every decision on this subject matter. My lords, I will then take you to the decision of Warburton and Loveland, which answers many questions that arose in this case. In Warburton and Loveland, it's important to say that this case was presided over by the Lord Chief Justice Tyndall, who sat with 12 judges of the House of Lords, and they gave a unanimous decision.
I don't think he did. What happens is the House of Lords used to ask the judges for their opinion. They gave their opinion, and then they chose, in this case, to adopt it themselves, but they didn't have to. He wasn't sitting in the House of Lords, Chief Justice Tyndall. He was just giving them advice. Opinion, which they could reject or accept.
Certainly.
But I think in the report it says that they entirely accepted it.
They accepted it, please, my lord. So, Lord Tyndall proceeds. He says, the language of the Irish Act is clear and explicit. We must give effect to it, whatever may be the consequences. That will be found at Electronic Bundle 986. I'm just going through what is found in the authorities. He says Section 4 of the Irish Act appears to be confined to the cases of registered deeds as between themselves. He goes on, the intention of the legislator was to provide a more public and notorious mode of transferring landed property, the means of discovering all transfers with equal or greater certainty by referring to a public register upon the face of which it was intended, they should all be found. The legislature contemplates that the parties to whom the conveyances are made will avail themselves of the protection of the Act or incur the consequences to which they become liable by neglecting its provisions. Those consequences are declared in the 4th and 5th sections of the Irish Act, which we say are in exact terms as the Trinidad and Tobago section 61.
Could you just give me that page number again? I was on the wrong one.
It's at electronic bundle 987 to 988.
Thank you.
Yes, please, Mayor. Now, this point that is going to be made, there are 2 points that I think are critical to this case. In relation to Warburton at electronic bundle, page 990 to 991. And I'm going to set out it says that it has been urged in answer to the construction of the 5th section that it is not to be taken by itself alone, but in conjunction with the 4th section, of which it is contended that one object was to control and qualify the operation of the next section. So they say there, a very similar argument, that the 4th section and the 5th section are one. They speak in one voice. They do one thing, which is the protection of the persons, the protected class in the 5th section of the Irish Act. And it is further urged that as the 4th section in declaring the effect and operation of registered deeds conveyances inter se gives efficacy to the first registered deed in preference to the second, not absolutely, but according to the right title and interest of the person conveying. A similar restriction must be understood to be imported into the 5th section also, and that the enactment which avoids altogether the prior unregistered deed as against the subsequent deed which is put upon the register must be understood with the same tacit restriction according to the right title and interest of the grantor in the second deed. The meaning of those restrictive words in the 4th section appears to be according to what would have been the right title and interest of the person making the second conveyance had there been no deed but what appears upon the register. In other words, there is no taking into consideration the unregistered deed. Only the deeds that have been put upon the register will affect the right title and interest of the grantor when he is making that second grant. He goes on, for unless this be the meaning of those words in the 4th section, that clause of the statute affords no protection at all. The clause, therefore, so understood, enacts in effect that every man who first registers his conveyance, where there is no other objection to the grantor's right to convey, except a prior conveyance made by himself and unregistered, shall be preferred to the man who registers at a subsequent time the conveyance made to him. This construction, on the one hand, excludes from the protection of the 4th section a grantee who has registered a conveyance made to him by a perfect stranger to the estate, and on the other hand, includes within its protection, as between two grantees, the one who first registers his conveyance made by the owner of the estates.
So was the argument that was being put was that those qualifying words, according to the right title and interest of the person conveying, effectively imported the rule that you can't give what you haven't got.
Indeed, so please.
And they said, well, if that's the rule, then this registration is pointless.
That's
because it's got to, the person with the registered deed has to get full title, even though the person who purported to convey that to them had already sold the land to somebody else.
Indeed, so please, Melody. That is the effect of the section. And it just goes a bit further. It's also at electronic bundle 990 to 991, where he applies that to the case that was at bar at that time. He says, at the time, therefore, that the lease of 1800 was made, it would have been good and valid. It would have been a good and valid lease, but for the unregistered settlement of 1979. So in that case, there was a marriage settlement that was made in 1979. That marriage settlement remained unregistered. The husband made a lease in 1800. So he's saying there that it would have been good and valid, it would have been a good and valid lease, but for the unregistered settlement of 1979. Because the argument there was that the 1979 settlement would have left him with no interest, because it would have all gone to the trustees. He goes on, the case, therefore, of these leases, if there had been a subsequent registration of the marriage settlement, so I say that this is very important because this is precisely what has happened in this case. The marriage settlement was not registered. In the intervening period, there was a disposition of the property, and thereafter, there was a registration of the marriage settlement.
After the lease had been...
After the lease. I shouldn't say it that way. There was no registration of the marriage settlement. What he's explaining here is this. He says, if there had been a subsequent registration of the marriage settlement, this would have been argued upon the fourth section, which is the exact section 16.1 of our Act. So he's saying, as it is in our case, there was a marriage settlement in 1979. In 1800, there was a lease created. Lord Tyndall is saying there, if there was a subsequent settlement, subsequent registration of the marriage settlement, the case would have been argued upon the fourth section of the Irish Act, which is the section that gives priority to the first registered deed.
But the lease had already been registered by the time
That's
the marriage settlement. Well, the marriage settlement was never registered, but the lease had been registered. So they're assuming what would have happened if the marriage settlement, although occurring before the lease, had only been registered after the lease, and they say, well, the lease would still have
prevailed. The lease would still have prevailed, and it would have prevailed because of the clear terms of Section 4 of the Irish Act, which is that priority is given to the first to register. So what this case does is that it answers many questions, and it has been adopted in the decisions that follow. What this does, it answers many questions. It answers the question of interest and the nemo dat principle. It answers the question of whether or not a person who registers subsequently, even though their lease their interest had been created prior, and they register after in time, whether they would be able to claim a priority over an intermediary who has registered in that period.
So it's saying that registration doesn't operate retroactively to the date of the deed.
No, please, milady, it does not as well. As well, that is also implicit in the decision, that registration does not relate back to execution.
You're going to read the next paragraph on 814 as well. It's been further argued. Sorry, on 991.
It is urged that the fifth section.
It has been further argued on 991.
It has been further argued that the effect of the marriage settlement was to prevent the husband from having any right to grant the lease of 1800 at the time it was made for that the wife was for that the wife's right was effectually conveyed as between her and herself by the deed of 1779, that she had no interest in her at the time she married, that she could therefore pass no interest to her husband by the marriage, that the husband consequently never had any right and therefore could convey none to the lessees. Now it may be admitted that as against the husband who was party to the lease, to the deed of 1779, that deed was valid. It may be admitted also that he could not of right exercise any power over the property inconsistent with that deed. But as by the non-registration of that deed, the grantees suffered him as to the world at large to have the appearance of right, neither they nor any claiming under them are at liberty to set up the deed in opposition to the persons who have been deluded by the appearance of the right in the husband.
And the final sentence.
The argument, therefore, which would be good against the husband himself cannot be heard from the parties claiming under the settlement against his grantee for a valuable consideration.
Because the lessees gave valuable consideration.
In that particular case, the lessees did give valuable consideration, but there is as well case law that makes it clear that it is whether or not the deed is for valuable consideration makes no difference.
Under the Irish Act.
Under the Irish Act.
Yeah. It's interesting that in Bushel and Bushel, the purpose of the Irish Act is expressed to be for the protection of purchasers, not for the protection of people who just want to get a leg up into a better position than the person who granted to them, knowing of an earlier unregistered deed. I think it's the origin of the fraud exception.
Yes, please.
But it also contains a very clear statement of the purpose.
Yes, please.
Which would be fulfilled, for example, in Warburton and in Bushel. But it'd be interesting to see if there's any case in which the person who's got the benefit of the equivalent to Section 16.1 wasn't a purchaser, but someone like the recipient of property under a...
Well, if the facts had been reversed in Warburton, if there'd been the lease that was unregistered and then the marriage settlement, which was a voluntary disposition,
it would have
not the
prevailed.
position in Warburton. You say it would have been the same under the Irish Act.
Yes, please, my lady.
But I'm assuming that in your obviously very considerable research, you haven't found a case the other way round, where the party getting the benefit of Section 16.1 or its equivalent is the volunteer rather than the purchaser.
I haven't quite found a case, but I found the expression in the House of Lords decision of Lord Newberry, where it says, the Irish Act expressly extended to all deeds, whether for value or not, and gives them as between each other according to the priority of their registration, priority in operation.
And the page number of that?
That couldn't be found at electronic bundle 1010.
1010.
Yes, please, my lord. That's a decision of the House of Lords again.
Okay.
As I understand it, if the executors or the recipients of the heirs had known of the other deed, then it would be fraudulent for them to assert a title against it. Isn't that right?
Yes, please, my lord. It would have been fraudulent, perhaps.
And which Lord Reedsdale says is that the Act is always saving that, so that it's not protecting somebody who knows that of the position.
That's correct, please, my lord. But of course, the facts in this case do not suggest that
No.
any of the executor nor the beneficiaries claiming under the deed of assent had any knowledge of this. In fact, it's quite in the reverse.
And if they didn't, then the object is not only to protect them, but it's to protect people who buy from them, who want to look in the register and see and know the position by being able to see what deed is first registered.
That's correct, please, my lord.
And they are providing valuable consideration.
Indeed so, please, my lord.
Yes, the example which is given in the Drew and Lord Norbury case is that of two voluntary deeds. Deed 1 first, Deed 2 second, but registered in reverse order.
Yes, please.
And then Deed 2 takes priority. So that is a case, by way of example at any rate, although not necessarily decision, of the voluntary recipient getting the benefit of the section.
Yes, please, my lord.
Yes.
It is indeed so, a position between voluntary deeds,
But
please,
that
my lord.
was that on the basis of the Irish Act?
Yes.
Yes, please, my lady.
Right.
Yeah.
Which doesn't contain the words about a purchaser for value.
At section 4, please, my lady. It makes no distinction between valuable consideration or not. So I'll move swiftly to Drew and Norbury, and the important points.
If you look at page 1010,
Yes, please, my lady.
just about 3 inches up from the bottom of the page, it says, the acts in the two countries differ. It's impossible not to be struck with the circumstances that though both acts passed in the same year,
Yes.
the English Act went no further than to protect a purchaser and gave voluntary deeds no greater validity by reason of their registration than they had. The Irish Act expressly extended to all deeds, whether for value or not, and gives them as between them each other according to the priority of their registration, priority in their operation.
Yes, please, my lady. It's precisely what I was about to read, that it makes no distinction whether it is one deeds for valuable consideration or not. And we say as well that in the Trinidad and Tobago section 16.1, no distinction is drawn between whether the deed is one for valuable consideration or not. Again, Drew and Norbury, the House of Lords, again stated that the construction of Section 4 of the Irish Act is perfectly settled. The priority of registration is made in every instance the criterion by which the priority of right is to be established. This is the result of the words used by the legislature in Section 4, and doctrines of the Court of Equity must give way to the express words of the legislature. That could be found at page 1009 of the electronic bundle. In Derbyshire, the High Court of Australia accepted and adopted the principles laid down in Bushell and Drew and Norbury in a case involving the construction of the Victorian statute that was similar in terms to the Irish Act. In that case, Lord Griffith, with whom Lord O'Connor and Lord Barton agreed, the effect of the language of the Victorian statute, which was founded on the Irish Act, in substance, was that registration prevailed. And even in that act, please, my lord, in the Victorian Act, what we saw is, but they did not even have the exact words of the Irish Act. We say in the Trinidad and Tobago Act, it's almost the very same words. The Australian Act that they were construing, it stated, the deed, conveyance, or other instrument in writing first registered shall have priority over every other deed, conveyance, or other instrument in writing whatsoever and howsoever conveying, charging, or affecting the same lands, tenements, and other hereditaments. Now, that section does not even start with a mandatory imposition to register all deeds. It's at page 1041 of the bundle. So it does not even start with a mandatory imposition to register all deeds. It does not even use the words good and effectual at law and in equity. And the Lord Chief Justice there was saying, notwithstanding all these distinctions between it and the Irish Act, it was in substance founded on the Irish Act. And the authorities that have laid down registration prevails were applicable. And he doesn't only do that in reliance on the authorities. He says on a construction of the act, this is the effect of it. He also points to the decision of the New South Wales Court of Appeal in saying that this approach has not only been adopted in the Victorian situation, but in New South Wales, they have also adopted the same construction of the act. I move to Delorey and Guardian Asset Management, which is a decision of the Privy Council. As I pointed out earlier, the board considered that Section 16.1 and Section 16.2 are independent of each other in that case.
Can we have a page number?
Where are we?
I'm at electronic bundle 1085.
Thank you.
So it starts off there where the board is saying, it is at paragraph 56.
56.
Yes.
What do you mean 46? I don't know. 1085.
56, please, my lord.
56 is the conclusion, where
On page
46,
1088.
please, my lord. It's at 1085.
well, 1085
Don't-
is paragraph
I'll take it from my written submission.
4 to 47.
Yes, so it starts at paragraph 46
Yes.
and goes to paragraph 56. And they're dealing there with the issue of registration.
Yeah.
They said issue 2 only arises on the assumption that, contrary to what the board has held above, the deed of settlement was effective to create a trust in relation to the Victoria Square property or otherwise to divest Ms. Delorey of her beneficial interest in the property. GAM submits, Guardian Asset Management submits, that even if this was so, the failure to register it meant that the rights which would have been created are ineffective as against Guardian Asset Management as a registered judgment creditor of Ms. Delorey. And I will try to skip some of what is there and go to paragraph 48, which sets out some of the facts. The facts relevant to the issue are not in dispute. The deed of settlement was executed on the 8th December 2009, but was never registered. GAM obtained its judgment on 25th October 2011 and registered it on the same day. I move now to paragraph 53. It is common ground that if effective to create a trust or disposition of a beneficial interest in relation to Victoria Square, the deed of settlement was required to be registered under 16.1 because it was a deed whereby any lands in Trinidad and Tobago may be in any way affected in equity. They go on. At paragraph 54, in the board's view, the priority as between the equitable interests purportedly created by the deed of settlement and those arising from GAM's registered judgment is determined by section 16.1, not section 16.2. Priority in accordance with the time of registration governs equitable interests arising from registrable deeds and the interests of the judgment creditors, where the judgment creditor is the same person as the grantor, including for that purpose the settler, under the relevant deed. The operative words of section 16.1 may be extracted as follows. And every such deed duly registered shall be good and effectual in equity according to the priority of time of registering such deed against all creditors by judgment of the same person so conveying the lands. And of course, what I say is that it does not only include in equity. It says it's good and effectual both at law and in equity. So that what the board has done here is that it has paraphrased the section, but the section itself says that every such deed duly registered shall be good and effectual both at law and in equity, according to the priority of time of registering such deed. They go on at paragraph 56. The board considers that this analysis is probably correct, but that it is unnecessary to decide the point. even if section 16.2 amounted to little more than belts and braces, the board is satisfied that section 16.1 is sufficient by its clear terms to regulate any competition for priority as between the equitable interests arising under a deed and those arising under a registered judgment, which are of the same as those of an equitable charges in accordance with their respective dates of registration. So that we say that the upshot of this is that section 16.1 and section 16.2 are sections that are independent of each other. One is designed to regulate the priority, any competition between deeds. Section 16.2 is of a wholly different character. It protects a certain class against unregistered deeds. Those are subsequent purchasers. And
so you are saying then, you must be saying then that where that if Mr. Bovell had never registered his 1979 deed, then he would be in a stronger position, because then it would be under 16.2 and the Jackman family members are not purchasers for value, so then he wouldn't have been overridden by their registration. But because he registered it in 2015, then they are both registered, and then even though they're not purchasers for value, their deed takes priority. Is that your case?
it's not entirely my case, please, my lady. What I'm saying is that 16.2 protects a subsequent purchaser, not a prior purchaser. 16.2 is clear in its terms that it protects a subsequent purchaser for value.
Subsequent to what?
Subsequent, as in the person who receives the second grant. So, for example, let me take you to Ramdale and Payne, which was dealt with under 16.2 by Lord Russell.
Where's that?
That can be found at
$1094.
1094. So I'm going to take you through Ramdale and Payne. Now, in Ramdale and Payne, the board again considered Section 16 of the Registration of Deeds Ordinance. It was the ordinance at that time. The facts were that in 1960, Beatrice Aberdeen, the owner of the property, leased Lot 71 to the respondent for 25 years. On March 26, 1964, the owner then executed a voluntary settlement of the land, conveying it to herself and the appellant, Ramdeo Mahabir, and a third person as trustee. The trust was for herself for life, with the remainder to the appellant and the third person as joint tenants. Then, on the 4th of July 1964, the owner then sold and conveyed the same Lot 71 for valuable consideration to the respondent. This instrument was intended to merge the existing lease into the freehold. The voluntary settlement was registered on the 26th of August 1964, and on the 3rd of September 1964, the conveyance to the respondent was registered. So in that regard, he is now a subsequent purchaser. So this is what Lord Russell is saying. Shortly after the registration, both the owner and the third-party trustee died, leaving the appellant as the sole surviving trustee and beneficiary under the settlement. The whole question on the appeal is whether the fact that the conveyance of Lot 71 was not registered until after the settlement was registered deprives the respondent of the ability to say that he owns the freehold. This depends upon the relevant statutes. Malone J. at first instance held that it did. The Court of Appeal of Trinidad and Tobago held that it did not. He then set out the statutory framework. He starts at section 3, then he goes to section 16. And at page 271, which can be found at 1098 of the electronic bundle, he says, counsel for the appellant contended that the system of
I think you mean 1097.
Yeah.
1097, please, my lord. Yes. Counsel for the appellant contended that the system of registration of deeds such as these involved a simple proposition, which seems to have been accepted by Malone J., that priority of registration was the answer to the case. Consider, it was said, section 16.1. There are two deeds purporting to convey the same land, lot 71. The settlement was duly registered, and therefore it declared to be good and effectual against the second deed according to the priority of time of registering. Their lordships, however, consider that the solution to this case lies in section 16.2. So first of all, he's saying these are two different sections, right? The respondent was a subsequent purchaser. That's important. He was a subsequent purchaser of lot 71 for value without notice of the settlement. His right was a right to have the settlement adjudged void as against him.
So it was subsequent to the
grant.
settlement, but not subsequent to the registration.
That is correct, please, my lady. Right?
Yeah.
So he was subsequent to the first grant. He came after the grant.
Right, but
Right,
at the time
even-
he got the grant, the previous settlement had not been registered.
That is correct, please, Marie. So that is why that was treated as unregistered, because by the time he got the grant and he became a purchaser for value, the settlement was not yet registered. So he was a purchaser for value as against an unregistered deed. And he fell into section 16.2. And the court goes on to say that his right was a right to have the settlement adjudged void as against him, it not having been registered at the time when he became such a purchaser. That right crystallized then and could not be taken away from him by subsequent registration of the settlement.
Yeah.
The important word in that section is that he was a subsequent purchaser. The section makes it clear that you have to be a subsequent purchaser to attract the protections of that act.
Was this case drawn to the board's attention in the Delorier case?
No, please, my lord.
I'm sorry?
No, please, my lord. It was not mentioned in the Delorier case.
I'd rather suspected that, yes. Well, it offers an explanation for the reason for 16.2, quite different from the one that was being canvassed as possibly or probably correct.
Indeed so, my lord. Indeed so, my lord. That is correct.
It seems to me if that authority had been cited to the board in Delorier, then they would have said, well, that's why you need section 16.2.
Indeed so, my lord. And he goes on. The phrase, whose conveyance shall be first registered, cannot mean whose conveyance is registered before the settlement is registered. Such a construction would deprive the subsection of all content, since in that case the registration priority under subsection 1 would suffice for the purchaser under the second deed. In other words, if the purchaser under the second deed had registered first in time, 16.1 would have sufficed. But that is not what happened. He became a subsequent purchaser before the voluntary settlement was registered, and therefore he is to be treated as a subsequent purchaser for value against an unregistered deed. And Lord Russell is acknowledging and accepting here, Section 16.1 is of a different nature. If he had registered first, 16.1 would have cleaned this up.
But he's also saying you have to read 16.1 and 16.2 together. Isn't he?
Well, why does my lady say that?
Because 16.1 of itself doesn't give the answer. You have to look at the scheme.
Well, he is in fact saying that you have to read 16.1 and 16.2 together, but he is saying that they are independent of each other as well. Even though you read them together, they are doing different things. Because he is saying that the priority created by Section 16.1 would have sufficed if the purchaser had simply registered ahead of the voluntary settlement. That would have been the end of the matter. And I say that he would have accepted what Malone J. said in the first instance case. It would have been a simple case of 16.1. But it's not 16.1, it's 16.2. So that, please, my lords and my lady, tackles the position in relation to the case law. And we submit that there has been a consistent and well-settled interpretation of Section 4 of the Irish Act across the
So
common
that
law.
in that case, even though the settlement was registered before the lease was registered, at the time that the lease was actually executed, the settlement had not been registered.
Yes, please, milady. So
if you looked at the register, you would see the settlement had an earlier date than the lease.
Yes, please, milady.
Right.
Well,
That didn't govern it because of 16.2.
because of 16.2. And what?
Not I think the lease, but the freehold reversion. The lease came first, didn't it?
The lease came first, but I think
What
milady
they
is
call
talking
the
about the
then there was the
settlement.
voluntary settlement.
Conveyance.
The settlement.
Yeah, then there was the settlement,
Yes.
and then there was a conveyance of the freehold reversion of lot 71, so that it merged in the lease. That's item 3 on page 1095.
So,
Then the settlement is registered, and then the conveyance of the freehold reversion is registered.
yes, please, my lord. So what is happening there, please, milady, is that the voluntary settlement was in fact registered first. And by virtue of 16.1, when looking at 16.1, one would say, well, first in time prevails. But then there is 16.2, which is a wholly independent section. And in this case, the facts were that at the time that they entered into the sale agreement for him to become a purchaser, where his rights crystallized, that is what Lord Russell is saying, that his rights crystallized when he entered into that agreement as a purchaser, and therefore at that point he became a subsequent purchaser for value against an unregistered settlement. So 16.2 that's the point of 16.2, and that's what I was.
And it doesn't prevail over section 16.1 as a matter of construction. It's simply that it renders that transfer void.
Indeed, so please, which is
against the purchaser for value.
That's correct, my lord. That is what it does. It provides a wholly different remedy, which is to render it void and fraudulent as against the unregistered lease.
Well, with that piece of enlightenment, you've just about got to the end of your time. Do you want to sort of wrap up?
Yes, please.
You've done a very detailed written case from which we've understood where you're going and where you're hoping to get to. But I must point out we're just coming up to 12 o'clock, which I think... And you have got some reply time, of course. If you wanted to eat into some of your reply time, you could continue now. It will come off your reply time.
I would be happy to do that, please,
Okay,
to eat
fine.
some of the reply time up and then come back to it. Because I'm going into the respondents' written submissions,
Yes.
and I'm going to be very quick about that. right? The first thing we say, please, my lord, is that they have laid heavy stress on the authority of Devi and Roy and all the authorities that have emanated from the principles adumbrated in Devi and Roy. And we are saying that this is not a Devi and Roy case. So we can lay that to one side. We are not, yes. So we can throw that to one side. They have gone through the statutory framework. I think that we too have properly gone through the statutory framework. One of the points I think that should be made is that they have looked at the heading of Section 16 and they have said that the heading is for the protection of the heading is a good indicator, as it were, for that the section is designed for the protection of purchasers and mortgagees. But the section's heading, in fact, says priority of deeds and the protection of purchasers and mortgagees. So we say the function of Section 16 is a dual function. Section 16.1 dealing with the priorities, and if one looks at the side note of Section 16.1, it is wholly different from the side note associated with Section 16.2. At paragraph 42 of their written submissions, which is to be found at electronic bundle 818, the respondents have referred to the text gray and gray on the elements of land law in support of their argument that deeds which are not for valuable consideration should be treated differently. We've looked at the text and we've looked at what is cited in the text. That we invite the board's attention, therefore, to the fact that the statute that was under consideration in that text was the Land Registration Act of the United Kingdom 2002, in particular Section 29.1. When one looks at Section 29.1, it expressly refers to dispositions for valuable consideration. So there's express language in that section that deals with valuable considerations. It's a wholly different section from what is before the court today. At paragraph 45 of their submissions, the respondent incorrectly analyzes the decision in Ramdeo and Payne. I've just been at pains myself to take the board through the decision in Ramdeo and Payne. I think that my lords and my lady have understood the decision, so I will not spend much time on what I say is an incorrect analysis of Ramdeo and Payne. At paragraph 47 of their submission, the respondent again has incorrectly analyzed the Laurier. And as my lord quite pointed out, that had Ramdeo and Payne been cited to the board in the Laurier, the board would have understood the distinctions to be drawn and when they should be drawn between 16.1 and 16.2. At paragraph 52 of their submission, which is a very important point, I think, for the appellants, they have cited the authority of Rollet Family and Company Limited and Rollet. Now, it's at 12:15 of the bundle. This is important, please, my lords and my lady. So the facts in Rollet, to put simply, was that the father, Emmanuel Rollet, made a deed of gift to his daughter Enna for certain plots of land. He later conveyed the same plots of land to a family company. The conveyance to the Rollet company, the conveyance was registered prior to the conveyance to Enna, even though the conveyance to Enna was executed first. At paragraph 3 of the decision of Lord Sumption, I think this is critical because this is what Lord Sumption was prepared to accept. This is at page 1217 of the electronic bundle.
Yes.
So Lord Sumption, after setting out the factual matrix, he says at paragraph 3, under section 10 of the Registration of Records Act, that is the Act of Bahamas, chapter 187, successive conveyances of the same land take priority in the order that they are lodged and accepted for record in the Bahamas Registry of Records. On the 22nd of May 2007, stamp duty was paid on the conveyance in favor of the company, and on the following day, they were lodged and accepted for registration in the registry. So remember, Enna's conveyance is executed first, but the company's Enna's deed of gift, is executed first, but the company's conveyance, though executed second, was registered first. He goes on, Enna stamped and lodged the deed of gift in her own favor 8 weeks later on the 18th July 2007. These are the important lines. It follows that if the conveyance in favor of the company were valid, it has title in priority to Enna. The rest of the case really goes on into dealing with why the conveyance to the company was not valid, because at the time, the company did not exist. Yes. But the point Lord Sumption is making is that it's a simple question of priority associated with registration. First to register, first in right. So it would have been that simple if there were not other defects associated with the validity of the conveyance. And again, it is noteworthy that in Rollet, there was no question of the nemo dat principle of interest remaining. There was none of that. It was a simple case, as I've said, of register, priority. In closing, please, my lords and my lady, we say that the difficulty faced by the respondents does not go unnoticed by the appellants. The respondents have expended large sums of money to purchase the property. However, we say that these difficulties would have been avoided by a more diligent search of the land registry of Trinidad and Tobago. It boils all down to that. A more diligent search of the land registry would have shown that this deed existed, and it would have avoided all of the consequences associated with the, I would say, go as far as saying negligent search of the land registry. We also remind the court that this case, though it involves the appellants and the respondents as private litigants, it also involves a matter of public interest, since it deals with public records and how title to property can be deduced from a search of the registry by members of the public at large and attorneys at law. If the court decides that unregistered deeds might yet gain priority over registered deeds, it runs the risk of creating a bifurcated system, or bifurcated or parallel system, which will have the effect of undermining certainty in the registry and creating chaos in the area of conveyancing. It also opens the door to more fraudulent transactions, because all it will take at this point, please, my lords and my lady, is for somebody to have a fraudulent deed sitting down at home, and they backdate it. They say that it is unregistered, and they present that deed at some late point, in some cases after the death of the person that is said to have granted them the deed. They appear in the office, they make false declarations, which are clearly on the record.
Well, that's not anything to do with...
Yes, please, Milady, it is not. But I'm just saying that these are the things that may occur if we adopt a treatment where unregistered deeds have the sanction of priority in the full face of legislation which says otherwise. And that is precisely what the Parliament in 1884 was trying to avoid. Unless I can be of any further assistance to this court, these are my submissions.
No, thank you very much. That's very helpful. Now, Mr. Takla Singh, you're still hearing all right?
Yes, I'm hearing you.
And you are loud and clear, so please start your submissions. You're obviously, you started, I think, about 12 minutes late, so you'll be able to go on a little bit longer than the original plan.
Yes, well, my lord, I fear it may not be as long as I had initially estimated, having regard to some of the questions that have been asked of my learned friend, Having regard to what he said, I wish to put certain propositions forward for the board's consideration. The first proposition I wish to put forward is that it could not have been the intention of Parliament for Section 16(1). My lords, are you hearing me?
Yes.
Yes.
Yes, I apologize. It could not, my first proposition, it could not have been the intention of Parliament for Section 16(1) of the Act to operate in a manner to permit an individual or an estate, as in this case, to be able to either pass title to property or write interest and title in property to property which they did not have a right interest and title in by virtue of registration simpliciter. In my view, Parliament would not have designed Section 16(1) to say that the location of title of property would merely be dependent on registration simpliciter. In other words, the Act, Section 16(1) has to be read as a whole, all of the words of the Act, so that you only get the protection of priority of registration if you have a right, title, and interest to register, meaning the right, title, and interest of the person conveying the lands, and that is in the Act. I say, my lords, I say that it could not also have been the intention of Parliament to reduce location of title merely to the swiftness of registration of a deed, but ignore the weight of the deed or what is behind the deed. And my support for that comes from Section 16 itself, the language of the Act, which I think is very clear. And if I could just read, I know their lordships have probably read the section a number of times, but I would take it from every deed. It's just to remind your lordships, electronic model, page 834. Every deed whereby any lands in Trinidad and Tobago may be in any way affected at law or in equity shall be registered under this Act, no dispute there. And every such deed duly registered shall be good and effectual both at law and in equity, no quarrel there on our part, according to the priority of time of registration, registering such deed, according to the right, title, and interest of the person conveying such lands against every other deed. And that is where I pause, my lord, to say that, of course, in the case at bar, our primary proposition is, by virtue of the 1979 deed, Mr. Choi Min San had divested himself of the title, of the legal and equitable interest in the property. He was the conveyor. Yes.
But on your construction, it would seem that Section 16(1) has no effect on the right or interest or title. The way you read it, it all depends on the order in which people actually acquired their rights or title, and when they registered, on your interpretation, doesn't alter that, and so it would seem to have no effect at all.
Well, we say, my lord, that if the deeds that you register don't carry the title or the weight of right, interest, and title, then you are not entitled to the protection of the register. But if you did, the priority of registration. But in fact, if you did register, respectfully, if you did register a deed where you had the right, interest, and title of the property, or the conveyor had so, then you are entitled to the protection.
Well, you're saying it gives you no more protection than you would have had anyway.
Well, under law, under the general law, that's what I'm saying.
But isn't that exactly the argument that was rejected in Warburton and Loveland, where they said it's not, those words don't say you can only give in the subsequent transaction whatever right, title, and interest remained to you following your entering into the unregistered conveyance, but they were saying no, the point of 61 is to overcome the nemo dat rule. Wasn't that the point of that case?
Well, what I would say in relation to the Warburton case is that, first of all, the court in Warburton was primarily concerned with the 5th section of the Irish Act, which is section 16.2 of our Act. So if I could give you the reference immediately, it's at electronic bundle, page 987, and it's the second paragraph of that page. Page 810 of the judgment, and electronic bundle, page 987. So when considering the issues in the Warburton case, the court said that the question appears to turn almost entirely on the construction of the 5th section of the statute, which declares in what cases, under what circumstances, an unregistered deed shall be void. So they were dealing with our section 16.2 case there, not necessarily 16.1. That is, of course, reinforced over the page at 988. It's I would say the 3rd paragraph down, where it says the 5th section in the middle of the 3rd paragraph, the 5th section upon which this present question turns, states the effect of the registration, and then it recites the language that is similar to our 16.2. Now, interestingly, as we are on that authority, just lower down, the court in Warburton, having analyzed the 4th and 5th section and earlier sections of the Irish Act, says this. It's at the 4th paragraph, the 2nd paragraph up, from the bottom of the page. Yes. Again, electronic, page 988. From this general view, therefore, both of the preamble and of the 5 first clauses of the statute, we think it cannot be doubted, but that the statute meant to afford an effectual remedy against the mischief arising to purchasers for a valuable consideration from the subsequent discovery of a secret or not concealed conveyances or secret or concealed charges upon the estate. So respectfully, I accept that the Warburton case, in considering that according to part of 16.1, did say that, look, there may be some, it may make nonsense of the act, but in my respectful view, in Warburton, the case was the court was really focused on the section 16.2 question and the question of valuable consideration or purchaser for valuable consideration.
But they do directly consider your argument on page 990, don't they? Just below the number 499 in the middle of that page, when they say that it's further urged as to the 4th section, and they go on then to summarise what I think is the argument that you've just made to us.
Yes, but and of course, respectfully, I say that my answer is, while they do say that, the court here, respectfully, would seem to be focused on the 16.2 question, because in Warburton, the facts were somewhat different to what we have here. In Warburton, it concerned a competition between a marriage settlement deed and a subsequently registered lease. But in Warburton, from my reading of it, the husband who conveyed the lease in 1800 had an independent right to do so. Meaning, when I read the case, by virtue of him marrying in 1800, he was able to convey the property in his own right. So he had title vested in him upon the marriage, not necessarily because of the marriage settlement. And I say that therefore that is unlike the case at bar. Or
the facts may be different, but do you say they are wrong when they interpret the words that you rely on, and they say the meaning of those? I'm looking back at 990, a few lines down from the 499 number. They say the meaning of those restrictive words in the 4th section appears to be according to what would have been the right, title and interest of the person making the second conveyance had there been no deed but what appears upon the register. So do you say that's a wrong construction of the section?
I respectfully...
The 12 judges were all wrong.
Respectfully, I disagree with that interpretation, most respectfully. I say that the court there was focused on the 16.2 question, and that phrase had to do with the section 16.2 question.
So that even if the grants had been purchasers and Mr. Choi had purported to sell it to two people, because he no longer had legal title when he purported to sell it to them because he'd sold it to Mr. Bovell, even as purchasers, they wouldn't have been able to take priority, because even if they'd been registered first. Is that what you're saying?
Well, the 16.2 question would answer that. So that if even if you had a purchase that was unregistered, even if you had a purchase that was unregistered, or you had an unregistered deed, it would be deemed to be fraudulent against the subsequent purchase that is registered. But that, of course, is not the case here.
Well, you've cited to us the trenchant statement of the purpose of the Act in Warburton, namely to protect purchasers. But how do you deal with a case like Drew and the Lord Norbury, where, as far as we can see, it was a competition which didn't involve any purchasers at all? They were both recipients under voluntary deeds. And yet, nonetheless, the Irish equivalent of Section 16.1 was successfully used.
Yes, well, Malora, my only answer to that is that yes, 16.1 would regulate or could regulate voluntary deeds or deeds of volunteers in relation to priority. And that's why I suppose that you would have to read 16.1 and 16.2 together. It forms part of a coherent scheme. 16.2 also deals with purchasers where deeds are pulled out, so to speak, after you purchase. And therefore, I respectfully say that 16.1, just to summarize, 16.1 can't be interpreted in a manner to give title where no title existed.
But 16.2, as interpreted in the Ramdio case, I think is giving an extra protection, isn't it? In a situation where you don't have the protection of 16.1. Because if you look in the register, you won't find any registered deed. And if you come along as a subsequent purchaser for value, and there's nothing in the register at that time, then you're going to be all right, even if the earlier deed is subsequently registered first. But it doesn't detract from the position that where there is registration, priority is according to registration. And if there's something registered at the time you come to do your transaction, it takes priority.
Yeah, yes, I can accept that to some extent, but I still say respectfully that the according to right titled interest part of the Act must mean something. And especially when it's tethered to the person conveying. Because if you say that the person, whatever deed is registered, it can't be that I register a voluntary deed, that I do a deed of gift today for property I have no interest in, no right in, and I register it. And then subsequently, someone who did have a voluntary entitlement registered as well a deed of gift, because the person is the correct disponer, etc. And by virtue of me simply registering first that I'm entitled to the property, you have to carry the weight respectfully of title. And none of the Warburton cases, none of the Ushell line of authorities actually deal with a scenario where the disponer or the grantor has no title to convey.
Well, the Warburton case gives those words a very narrow interpretation, but it says all they do is prevent a stranger coming along and saying, well, I'm going to register a deed.
Yes.
Yes.
That's their interpretation anyway. So there is an interpretation of those words put forward in the cases that it's different from yours, which you need to contend with.
Yes, and I do contend with it, and I say respectfully, my contention is that the language appears to be clear. Yes, there may have been there is previous an interpretation, but I say in that case the court was focused on the 16.2 question. I would also say that some of the preambular recitals in the Irish deed are perhaps somewhat historical, in the sense that there appeared to be a specific problem in Ireland at the time with respect to prevalence of unregistered deeds between two sections of the society. And that is recited in the deed. I don't know that to be the case in Trinidad, that we have that issue that would lend to such a strong interpretation. So in essence, just to summarize that point, and I take the point of the Warburton case, but as I've said, in that
argument
case,
is not the argument that the Court of Appeal decided the case on. In this
no.
case.
In fact, the entire Bushell line of authorities for the first time has come up in the before this board. Our local courts have not had, or these cases were not unfortunately not cited either before the High Court or the Court of Appeal to adopt this type of interpretation. In fact, essentially what it was accepted in the Court of Appeal. It was conceded by counsel there for the now appellant, or for the appellant, that title had passed upon the deed being delivered. And I could give you reference to that in the bundle. Can give on 1 second. It is a page electronic bundle, just for your reference. Electronic bundle, page 615. It is the transcript of proceedings. And you will see at line 31, Justice of Appeal Musai, all right, but as a matter of law, do you accept that the deed takes effect from the date of delivery? Mr. Wilson, who then represented the appellant, said, yes, please. Therefore, it appeared to be accepted at the Court of Appeal that title had already passed upon the execution of the deed in 1979, so that the estate did not have, or the property ought not have properly formed part of the estate in the first place to get into the estate of the deceased, and then certainly thereafter could not have been assented to the beneficiary.
Did Mr. Choi's will, did it expressly refer to this land, or did he just leave everything to the...
Oh, no, the Mr. Choi's will, I believe, of 2013, which can be found at electronic bundle 438. It's made in electronic bundle 438. That's the will that her ladyship has asked about, and it does speak to the property. Item 5. The grant was thereafter the so to answer your ladyship's question, yes, the will did recite it.
Yeah.
Suppose that reminds me of the Bushell case, which I could treat with very quickly. simply to say that, again, the facts are entirely different. The Bushell case, you had a marriage settlement coming first, and thereafter, you had a will being registered subsequently. And all the courts held there was that the registered instrument, which was the marriage settlement, was to prevail. But again, there was no question that the marriage settlement could have dealt with the property in the way that it did. Again, our case is entirely different, and perhaps, I don't want to be as brash to say, but perhaps if the courts then were confronted with a scenario such as this,
What's
the
the page
interpretation
number?
may have.
Sorry, what page number is this case on?
It is at 967.
Sorry?
967 of the electronic bundle, my lord.
967.
Yes. And you could see, just as we are at 967, in the middle of the first page there, you talk about where John Bushell, you see the indented articles of agreement bearing the date 16th of January 1755. So that was the date of the agreement. And then over the page at 968, gives a short summary. The marriage took effect, etc. And then after the colon, but shortly after his death, 31st of July, shortly after, so you had two Bushells, I apologize. So the reading becomes a little convoluted, but shortly after the father's death, on the 31st of July, 1778, he duly made and published his last will. So, after the marriage, I apologize. So the competition between the two instruments were really the will of 1778 and the marriage settlement of 1755. And what the court said, well, it applied section 16.1, and the earlier registered instrument would prevail for the will. The case then goes on to a consideration as to whether the will gave notice of the interest, because the wife had endorsed, the wife was also a beneficiary of the marriage estate. The marriage settlement had endorsed the will, almost suggesting that she agreed with the content of the will. But the children of the first marriage were not having that unchallenged, and they said, well, no, we have to uphold the marriage settlement, which is the first registered instrument. And in that context, the court interprets section 16.1, which I suppose is the fountain of interpretation, the genesis of all of this jurisprudence of the section 4 of the Irish Act and section 16.1, and where all of the statements are made in relation to priority of registration. But again, that case, there was no dispute that the earlier marriage settlement could have divested the interest in the way that it did. And in fact, in the same is with Mill and Hill. Same facts are with Mill and Hill. In Mill and Hill, let's have a note. Yes, in Mill and Hill, the facts were simple. A man by the name of Sir George Hill executed two instruments. And that, just for apologies, that Mill and Hill is at 1014, the Mill and Hill judgment. The point I'm making, my lords, I'm not going to go through the authorities line by line. My friend has pointed you to the paragraphs, etc. But the point I'm making is that the Bushell line of authorities are distinguishable to some extent by virtue of the fact none of the courts treating with those authorities had to deal with the specific problem which arises in this case, that the disponer or the grantor did not have the right and interest to dispose of the property, and the deed that was eventually upheld as or given the priority of protection, there was no question of that instrument itself being able to pass property. And therefore, priority of registration works in that case. I've sort of jumped ahead to the cases, but I think your lordships have my point on the act. I also say, lordships and my lady, I also say that the Royal Family and Company Limited case, which is relied on at EB 1218, does offer some guidance, and if I could take your lordships there. 218. And I'm interested in page 1218, paragraph 8 of that authority. Now, Lord Submission there is dealing with the effect of an escrow deed. As your lordships, as the court would be aware, there was a lengthy escrow period in this case. So I felt that this is a good statement of law to be considered. At paragraph 8, Lord Submission says the real objection. Are your lordships with me? I apologize. I'm getting a little feedback. My lord, are your lordships with me?
Yes?
Yes.
Yes, I apologize. I got a little feedback there. I apologize. At paragraph 8, real objection to the supposed escrow is a more fundamental one, namely that a deed cannot validly be delivered in escrow on a condition as to the coming into existence of a grantee. So in that case, the escrow condition was that the company would be incorporated. This is because although delivery of a deed in escrow suspends the effect of the deed as a grant until satisfaction of the condition, it creates legally binding obligations from the moment of delivery, which is similar to the concession made in Court of Appeal. The maker of the escrow cannot, for example, recall it before the condition is satisfied or dispose of an interest in the land inconsistent with the deed being held, inconsistent with it, which of course I say is the deed in escrow. Now, respectfully, this deed came out of escrow. So it can't be the case respectfully, that a grantor cannot dispose of the interest in a deed being held in escrow. And then the escrow condition is satisfied, the deed is released in 2007, yet he is able to dispose of his interest. Or even further down the line, his estate is able to dispose of the interest to beneficiaries. And that, I suppose, is the main battlefield, so to speak.
The oddity here is that the will was made in 2011.
Yes.
Long after he'd sold the land to Mr. Bovell. If the will had been made in 1975, then it would have been obvious that between then and, I mean, if you make a will leaving property, if you make a will leaving property and before you die you sell that property, then nobody could argue that you had devised that house under your will just because you owned it at the time that you made your will. If you don't update your will, your beneficiaries can't insist on having that house. So it would be strange if the position is different because in a will post-dating the sale of the house, he purports to devise the house.
I agree. There's no passage of title by simply me executing a will. And I mean, that's obvious in the case of in Trinidad. We have the unfortunate problem where sometimes joint tenants execute wills thinking that they could pass an interest by virtue of the will when in fact right of survivorship prevails. So it can't be that merely because you execute a will, having divested yourself of the property, that somehow the property comes back into the estate, capable of being passed by virtue of letters of administration. And if I could if I could be allowed to test, your lordships could give me some latitude to test the rival interpretations of the section. In this case, you had an inordinate delay. I accept that. There was an inordinate delay of many years. But what if someone conveys property and then dies shortly thereafter? The purchaser for value, for good reason, has delayed his registration. He says maybe the stamp duty is too high. He needs to get some further money before he pays his stamp duty, or he needs to get a valuation. But the conveyor dies, the disponer dies, and then due to extreme diligence or officiousness, the administrator is able to get his grant and register the deed before the person who purchased for value. In those circumstances, it can't be that simply because you've registered, you got to the registry first, you crossed the finish line, got to the registry first, you registered your deed, that the purchaser is now out.
Well, that's because of Section 16.2. That's where that comes in to protect the subsequent purchase, the purchaser, though.
It could be, but all right, let's.
Or are you saying he's not a subsequent purchaser? He's
not a subsequent
prior
purchaser,
is he? He's a prior purchaser.
Assentee. Yes.
Well, if the personal representatives knew about the sale by the testator, which they should have done if they did their job properly in administering the estate, then they'd be caught by the fraud exception.
Well, they ought to, but you know, you can't say, for a general rule, respectfully, you can't say that the administrator may or may not know the entire estate. They ought to, and they ought to do searches. But if the deed wasn't registered and the deceased conveyed his land for money because perhaps he needed money at that point and didn't want to tell the family about it, or many scenarios could take in place. It doesn't mean that the person who purchased should be deprived of the title by virtue of swift registration.
But he could register, in your example, the purchaser, when the deed is made, should go and register it if he wants protection. In fact, he's obliged to, under Section 16.1.
Yes,
So
I agree.
It's his own fault if he doesn't. I mean, that's the view that could be taken.
It is a view, but I would say that that's I hate to use constitutional law language. It would be a disproportionate, or it would be a very harsh effect of the section, because as I say, we're looking at it in context in this case where there was a long period of time. I accept that, but when we interpret the law, we have to interpret for all scenarios. And therefore, in the circumstances where there could be a good reason why a purchaser for value has not immediately registered, yet the estate is granted quickly due to diligence. Perhaps they know more proficient attorneys, perhaps they know the registry ins and outs better, and they get their deed registered before the purchaser for value.
Yes, I mean, it's his fault. They should have checked, but the question is the punishment for that he loses his estate, he loses his property, even to the beneficiaries of the will of the person who sold it to him, and presumably got the money from him, which then he also devises to them under the will. So they get both the money and the property.
And he couldn't really check, respectfully, he couldn't really check at the time of purchase, because assent would only come after. I mean, I can say as a practice, many attorneys, they advise their clients to register the agreement of sale as well, so that at least there is something on the register, but that isn't necessarily what takes place. Because you may have a purchase without an agreement of sale. You may go straight to the deed. So that the effect is extremely disproportionate if you were to adopt the interpretation of what my friends are asking for. Backed by authority, I give them that. Some of the interpretation do say, but I do say, as I said, the Bushell line of authority is distinguishable because they haven't grappled with this specific problem, this specific issue that confronts us in this case. And that is why I attach a lot of weight, or I attach a lot to the in accordance with provision of the Act. I say that that brings you now to the position where if you are going to register a deed, you have to have it has to be in accordance with the actual, I read in accordance with, to me in accordance with the actual right, title, and interest of the person conveying the land. And if at that time, as in this case, he had divested himself of the 1979 deed, then he didn't have the right, title, and interest to be registered. It doesn't say, for instance, the language does not say in accordance with the right, title, and interest as expressed in the deed. If it had said that, well, then I would more follow the interpretation in the 1800s to say, well, you know, that is what you're coming with. But it's not just as expressed in the deed. It says which the conveyor has. The person conveying, the person. I should also say, because my friend made the point earlier, I should also say, because my friend made the point earlier about the searches that were done. That was not, on my reading of the transcript in the High Court, the searches were not impeached, and in fact, the searches are registered, in evidence that the conveyance, that the conveying attorney did. You can find the search, just by way of reference, you can find the search at electronic bundle 380.
Sorry, give me the number again.
As a practical matter, sorry, it's electronic bundle 380.
Thank you.
Yes, so you see the search has the header, and then when you flip the page, there's a letter that is set out describing the title of the search that was done. So a search was done in this case. Unfortunately, for some reason, it did not pick up this deed that was registered a few months before the assent, when the conveyance was being done.
So you say that the fault was not in the inadequacy of the search, it was just that what came back, in fact, wasn't accurate?
It was not accurate, and there is evidence of the attorney, Ms. Sanji Chase, in her witness statement, if I could locate that for you, where she does say that, having spoken to a clerk who does these searches regularly, that there is a lag. Sometimes there is a lag from when you actually put in a deed to when you can find it. And if I could put you to that bit.
What is it? A lag of several months, by all accounts.
I mean, you know, it's not an electronic registry that we have here, I can say that. No. In fact, when I started practice, to give me the experience, my senior in conveyancing sent me down to the registry with the clerk to see the process. It's about books, it's about writing up the deed in books, etc. So there could be a lag. It's not as though you scan a deed and you put it on an electronic system, as we are accustomed in court cases now.
To whom is this search instruction sent?
It was sent to the clerk.
Sorry, to who?
Sorry, my lord, I missed that.
But I'm looking at your page 380, and it's a search instruction. But I'm asking, to whom is the instruction given?
Name of title clerk.
So it's given to a title clerk. Is that a private person acting as an agent of the attorney's firm, or is it somebody within the registry?
No, what you have in Trinidad are title clerks that freelance. So you want to do a conveyance, you hire the title clerk, and the title clerk goes down into the registry to do a physical or manual check.
So in other words, it's not the registry taking responsibility for the search, it's just the attorney has delegated dedicated the conduct of the search to a title clerk who got it wrong.
Yes, and that is the practice.
We're not sure whether Nella Rivers did look, but this hadn't yet been put on the register, or whether it was there and she failed to notice it. That's what we don't know, I think.
That's right.
We don't have evidence of that. What I can say is that the evidence of Miss Sanji Chase at 367 was not challenged on that point in cross-examination. So at 367, let me just find it. At page 372, paragraph 18 of her witness statement, she describes what she did. She says that the clerk further advised that the computer printout for electronic searches did not include the deed of assent and the country books manual record did not contain an entry of same when the searches conducted in March 2015 and updated according to the closing on the 10th of June 2015. She informed us that there is some delay on the part of the Registrar General's office in updating entries in the country book.
Yes.
That was not challenged in cross-examination from my reading of the transcript.
Can you just help me?
That proposition.
Can you help me on this? I understand that the date of registration is the date at which the deed is lodged at the registry, not the date it's actually recorded on the register. And I can see that there could be a gap between the date when it's lodged and the date when it's recorded. But does that mean does it mean that a deed that had been lodged but not yet recorded would be missed out in the search? Because if so, it seems there's a rather fundamental inadequacy in the system.
Well, we may need, I suppose you would need conveyancing attorney expertise to answer that question. It's beyond me to say that definitive. But there is a lag, and I would say that there's no, it's not as though your title is guaranteed by virtue of it being on the register. So I know there are some systems, if it appears that this is the title, and then there is indefeasibility. But that's not the case in Trinidad.
No, it's just a deed register. But it
Yes,
does seem strange if there can be an effective date of registration in relation to a deed which can't be found on a search made after that date.
6 months later.
Yes. I mean, I can't give evidence from the bar table, so
That wouldn't be the only jurisdiction where land registries get seriously behind in completing applications. But 6 months does seem a long time.
Well, it's actually more than that. I didn't realise it's March 2015 instructions, so it's nearly 9 months later.
Yes. And that's the problem, where you could have an innocent purchaser for value who does a search, doesn't show up in the county book, doesn't show up in the electronic records. You take your search, and then someone who had no right to title, volunteer, to use the word, but trumps your deed. And so that is so when my argument is, when we're testing the interpretation, we also have to look at whether or not it results in an absurdity or a very harsh result. And I can say, as I said, that this Bushel line of authority was not considered by our local courts as to how it would interplay with our system of registry, our system of registration, the nuances of same. So therefore, respectfully, I don't think it should be applied in the way suggested by the appellant. And of course, again, it brings me back to the point that when the courts were considering the Bushel line of authority in the 1800s, they didn't have a case where someone didn't have title and was claiming, but there were no issues about lapse in registration or anything like that as well. Yes. I think our discussions has actually taken me through a lot of what I wanted to say. That is the interpretation that I argue for. I place reliance in that accordance with. I've pointed out to you that there was a little difficulty in the registration, that we had the registered, that a search was done. I've also said to you that, well, the other point I wanted to make is that you can't interpret the section to give an estate a greater title than it had, which of course flows from my earlier argument. But there is a paragraph in the authority of Mill, which can be found. Look at this. My tab seems to have slipped out. Yes, 1014.
Hill,
This is Mill and Hill.
Yes, Mill and Hill, I apologize.
Mill and Hill, yes.
Yes, and there is a, I mean, we have to take it in context. I don't like to just isolate paragraphs, but at the top of page 1030 of the electronic record,
10:15 you're going to?
1030, the electronic record.
30.
Oh, 10:30, I'm so sorry.
And yeah, 1030, I apologize.
Thank you.
At the top, I do not understand why that date is taken. So they were trying to determine in the case what date should be taken as for damages. I dare say he entered into possession in 1841, but then Sir George Hill was entitled to property during his life, and though his grant would not pass any greater interest than he had, yet during the term of his life, those who held under him were entitled to all the benefits he himself was entitled to. So it takes us, I suppose, to this case. He himself, meaning the deceased in this case, was not entitled to the property at that time. At the time, his estate was not entitled to the property. So his beneficiaries could not take more than the estate itself, or which form part of the estate. And I think that is a fundamental point. You can't, that's where the phrase that you can't give what you don't have. And certainly the estate
Well, it's
could not
rather
pass.
more than not being able to give you. I mean, the mischief is that people make their wills at a time when they have a certain amount of money and a certain amount of property, and then they live for another 20 years, and when they die, their situation may be completely different.
Yes.
They may have no money.
Yes.
But
Yes,
the beneficiaries
correct.
only get what they actually get that they had, not what he thought he had at the time he made the will. Or what he did
That's correct.
when he made the will, yes.
And insofar as my friend raises the policy argument about, well, you could have many fraud happening, a lot of fraud happening because things aren't registered. Of course, everyone wants a system where you can pull up a computer, look at a registry, and see exactly what is taking place with title. That's desirable. But unfortunately, it just doesn't exist. But the larger point would be that if persons, or the worst fraud, if I could put it that way, the larger cut would be if persons who had no title to property, or they were not purchasers to property, were simply able to register deeds and then claim title by virtue of registering their deed first by swiftness and not weight of the deed.
Well, it's an odd situation where the testator makes a will later, devises property that he's sold to somebody else, and doesn't tell his executor or the heirs about the previous transaction. It's a very peculiar case all round.
I don't want to say perhaps not in my experience, but
Oh, right.
I suppose.
But there is the more usual case that you referred to briefly, where there are joint tenants and they don't quite understand the legal effect of that, and so one of them leaves their half share of the property to somebody else, and when they die, actually it goes to the survivor, not
Correct. Jus a credit, as we're taught.
not to that person, and that person can have a deed of assent till the cows come home, but they still don't get that because it's gone on survivorship.
Yes, exactly. And that's why I say the right title and interest provision of the Act, we have to, I think, reconsider it or look at it in the context of our Act as a whole.
It's 1 o'clock, Mr. Singh, so we'll continue with your submissions at 2 o'clock.
Yes, well, my lord, I was about to say that essentially I think that is what I want to say. Perhaps if we're taking the break, if I have anything to sweep up, I will do so very shortly.
You can carry your bat until 2 o'clock our time anyway, in case there's anything else you want to add. Court's adjourned.